Good evening, everyone. Good evening. My name is Andrew Cianzo, president of the George Mason University Antonin Scalia Law School chapter, and alongside the DC Young Lawyers chapter and the student chapters from American, Catholic, DC, Georgetown, Maryland, and George Washington, I'm honored to welcome you to this Federalist Society Rupe debate on this Juneteenth holiday evening. We are thankful to the Federalist Society and the Arthur N. Rupe Foundation for fostering open dialogue by making this event on this important topic possible. While there are 9 people over at 1 First Street who certainly will have an opinion, well, probably a majority opinion, a concurring opinion or two, and a dissent, as soon as tomorrow on the meeting on whether the 16th Amendment authorizes Congress to tax unrealized sums without apportionment among the states, tonight we address a related but broader question. Is the wealth tax constitutional? To answer that question, we are honored to have 3 great legal minds with us this evening. Debating the proposition will be Professor David Schizer, Dean Emeritus and Harvey L. Miller Professor of Law and Economics at Columbia Law School, and Professor Akhil Reed Amar, Sterling Professor of Law and Politics at Yale University. But before we hear from them, I have the pleasure of introducing our moderator this evening, Corinne Snow, who will formally introduce our debaters and set the scene for our discussion. Corinne Snow is a counsel at the law firm of Vinson and Elkins. After graduating from Harvard Law School, she clerked for the Honorable Jennifer Walker Elrod on the U.S. Court of Appeals for the Fifth Circuit. She previously served in the U.S. Department of Justice, including as counsel and chief of staff in the Environment and Natural Resources Division. She also served as senior counsel in the Office of the Associate Attorney General, which oversees all civil litigation on behalf of the United States. She also is a lecturer at the Wharton School. Without further ado, please join me in welcoming our distinguished speakers.
Thanks, Andrew. Can everyone hear us all right? Great. So thank you so much for joining us tonight for this event. It's really great to see so many friends in the audience as well. I am delighted to get to moderate this debate between 2 preeminent scholars on the wealth tax. But before we get started, I would be remiss in not acknowledging that today is Juneteenth, the day that we celebrate the end of slavery in our nation. And we'll be getting into how the institution of slavery may have influenced the taxing authorities and the origins of them. And so that'll be part of our conversation tonight. Just to give you guys a little bit of a run of show, I'm going to introduce our 2 panelists. Then I'm going to lead a conversation with the 2 of them about the wealth tax. But then we'd like to open it up, and we'd like all of you to join in the conversation. So I'll give you a little bit of a heads up when that time is coming, but I hope you'll be thinking about questions you have as the discussion is going on. As you see, there's 2 mics here, so I'll give you a heads up when it's time to start lining up. And then after the debate, we're going to have a reception afterwards. So if you didn't already get a chance to grab a book and get a copy signed, or you haven't had a chance yet to have a chance to talk with Dean Schizer and Professor Amar, I really hope you'll stick around afterwards and take advantage of that opportunity. So without further ado, let me introduce our 2 panelists. So as Andrew said, we have Dean Schizer of Columbia Law School. He was previously the dean there between 2004 and 2014. He got the job at age 35. He's the youngest dean in the school's history, and the longest serving dean since 1971. He is a preeminent scholar on tax law, and his scholarship focuses on nonprofits, the energy sector, and also corporate governance. So we're very lucky to have him here with us tonight. He's also done some incredible work setting up a number of centers at the law school there, including one for Israeli studies, and took some time out of his academic career to do further work in that area as well. So he's also a double Yale grad from Yale College and Yale Law School. So we have 2 double bulldogs up here tonight. Should make for a fun fight. He also clerked for Judge Alex Kaczynski on the Ninth Circuit, and then clerked for the late Justice Ruth Bader Ginsburg on the Supreme Court. Professor Akhil Reed Amar is, as I said, another double bulldog, and he's also at Yale Law School now, where he teaches constitutional law at both the at both the college and the law school. He has been cited by Supreme Court justices across the spectrum in more than 4 dozen cases. He is one of the most cited legal scholars out there, I think in the top 5. He clerked for Judge, then Justice Stephen Breyer, and then joined the Yale faculty at age 26. So, look, we have 2 examples of you guys can do a heck of a lot of things early on in your career. So thank you both for joining us tonight. To kick things off, Dean Schizer, I was wondering if you could just talk to us a little bit about what we mean when we talk about the wealth tax. So this is a phrase that we hear in the popular media. There are proposals from folks like Bernie Sanders and Elizabeth Warren, but also from President Biden. So could you just kind of give us a context for what those different proposals are?
Absolutely. So let me start by saying what a treat it is to be here with all of you and with you, Corinne and Akhil. This is really wonderful. I do think there are really fascinating issues that we're going to cover, and there's a correct view and there's Akhil's view. But really, what I hope you'll take away is not that or not only that, but really, at a minimum, a bit of clarity about what we mean when we talk about a wealth tax. And so, Corinne, I'm happy to start there, because if you read an article that a journalist writes, they're going to blur it. So I'm going to start with a hypothetical example. Let's take someone who's really, really rich. Let's give him the hypothetical name of, I don't know, David. And let's say that David started a tech business in college and paid nothing for the stock, and now his stock position is worth $150 million. So let's say he doesn't sell the stock, he's just holding on to it. Under current law, what happens? Nothing happens. He hasn't made a sale. Therefore, that's called the realization rule. For those of you who've been to law school, it means there's no tax until you sell, no tax consequences. Let's say a year goes by, the stock price has gone down, 150 million to 140 million, again, no tax consequences. And let's say, sadly, David passes away, the stock is transferred to David's heirs. David is now thinking about whether his children deserve it, but that's a separate matter. And so the point is, we have a rule, which you may have heard of, the basis step-up, which means that if the heirs sell the stock for 140 million at that moment, there's no income tax, because they're treated as if they paid the price on the date of death, which means that from the US government's perspective, no income tax is ever collected on that $140 million of appreciation. Now, is there a tax? Yes, there's an estate tax, 40%, it's a significant tax, but in terms of the income tax, you don't reach it. So progressives have focused on this untaxed amount, and there have been a few different proposals, and let's start with the one that I mean when I say wealth tax, and this is something Bernie Sanders and Elizabeth Warren have talked about, and it means that there's a percentage that you pay on your net worth every year. So in my example, if this year, and their proposal was 2% for amounts above 50 million and 3% for amounts above $1 billion. So in our example, that first year, the stock price is it's worth $150 million. So that's 100 million above the 50 million threshold. So you have to write a $2 million check. You didn't do anything, but you have to write a $2 million check. Then the next year, the stock price declines from 150 to 140. So now we have 90 million above the threshold, and even though the value went down, and that's important, even though the value went down, you're still going to pay your 2%. This time it's 1.8 million. So that's what a tax lawyer like me means when we talk about a wealth tax. There's another kind of tax that President Biden proposed, did not get enacted, which is known as a mark-to-market income tax. And what that means is you're going to pay tax on changes in value, whether or not you sell. And so let's go back to our example. The stock price has gone to 150 million. That's income. because even though you haven't sold, you have this gain, Congress steps in, we're going to tax you now, and you pay tax, say 20%, which was the Biden number, 20% of 150 million, that's a lot, that's a $30 million check. In the second year, though, the stock goes from 150 to 140 million. You don't owe a tax again. There was no appreciation. On the contrary, the stock went down by 10 million. So actually 20% of that, 2 million, you should get that back in the form of a deduction that reduces your tax. So to me, that's not a wealth tax. That's just a type of income tax without realization. One more thing to know. We also had a proposal from President Biden getting rid of the step-up in basis. So when I said before, you die, you give the stock to your heirs, nobody ever taxes that 150 million. Well, his proposal was treat death as a sale, and you do pay tax. So that didn't get enacted either. But these are three different things people might mean. Getting rid of the basis step-up is one. Mark-to-market tax, that's two. In my view, those are both income taxes. And then the third, the wealth tax, you pay the amount regardless of whether the stock goes up or down.
I could definitely see why rich hypothetical David would not like the wealth tax.
Yeah, no.
So let's talk about where the taxing power comes from in the first place. And again, if I could impose on you to give us just a quick primer, what are the different taxing authorities? And could you just give us kind of your view of how that all works in the Constitution?
Sure. So it all started with the Articles of Confederation, where basically there was no national taxing power. Each state was supposed to contribute an amount, and it really functioned as a voluntary system. And when taxes are voluntary, guess what? People don't pay them. So a key motivation for the convention, Philadelphia Convention in 1787, was to fix that. And so the framers basically did two things, and then something was added 120 some odd years later. So the first thing they said is, you know what, the best tax, the tax we most want to rely on, that's a tariff, and just taxes on transactions. So Article 1 authorizes Congress to impose duties, imposts, and excises. Lawyers call those indirect taxes, even though it's not in the Constitution. An impost is a tax on imports. An excise is a tax on a domestic transaction. And there's a rule there, and the rule is they have to be uniform. So if cloth is imported in North Carolina, and if cloth is imported in Massachusetts, the same tariff rate has to apply. Uniformity for indirect taxes. There's a different kind of tax, direct taxes. The framers thought, well, we need this too, because we can't rely only on tariffs. If we do, and we're at war, and we have no navy, then at a moment when we really need revenue because we're at war, there will be no tariff revenue. So we need a different kind of tax. And so what Akhil and I will be debating is the scope of what a direct tax is. But the Constitution says a head tax is a direct tax. That just means you're a citizen, you're alive, you're going to pay an amount. And then property taxes, real property taxes, I think we both agree, those are direct. And then where I differ from Akhil, and we'll talk about this, is I think it also includes personal property. It also includes wealth taxes. We'll be debating that. But that would be, you pay a certain amount every year. Now, the thing is, those aren't supposed to be uniform. They're supposed to be apportioned. Apportionment is the second requirement. What does apportionment mean? It means, sort of think about the tax by state. And the amount of tax that is collected from each state is supposed to match the population of that state. And so, for example, let's say that Connecticut has about 3 million people, call it 1% of the US population. Mississippi also has about the same population, about 1% of the population. If you apportion a tax, what that means is that 1% of it needs to be collected in Connecticut, and 1%, the same 1%, needs to be collected in Mississippi because they have the same percentage of people. Why is this important? Because it turns out Connecticut is perhaps the wealthiest state in the Union, Mississippi not so much. And so in order to collect the same revenue from Mississippi, you're actually going to need a higher tax rate. And what apportionment boils down to is a higher tax rate in the less wealthy state, which is backwards, because we usually think, oh, wealthier, higher rate. So that's what apportionment means. Years later, There was a debate, Supreme Court decision, other decisions about whether an income tax needed to be apportioned. The Supreme Court went a bit back and forth on it, but with Pollock, they said, has to be. And so the 16th Amendment was passed, and that's the third piece, which is now we have a third kind of tax. Income taxes are spared from apportionment by the 16th Amendment. And then we have the question of what counts as an income tax. But basically the three categories are tariffs and other transactional taxes, indirect taxes, uniform. Direct taxes need to be apportioned. Income taxes do not have to be apportioned.
So Professor Amar, why would the founders have done this? Why would they have decided that direct taxes needed to be apportioned?
So first, it's great to be here. Thank you all for coming. It's especially fun to be with my old friend and former boss, David. He used to, speaking of income, he used to sign checks paid to the order of Akhil. And Akhil was very, very grateful to David for those. He helped generate income for my family. So thank you, David, for all of that and your friendship over the years. And since it's Juneteenth, my answer in one word about the complicated rules that David beautifully set out, and he teaches tax and I don't, day to day, slavery. Okay, so let me just take a step back, because we agree on a lot, and the disagreements are actually pretty modest, and I just want to highlight truthfully for this audience that from my point of view, he basically gave away the store, and I'm happy that he did at the very beginning, because he said in his hypothetical with that fellow David, oh, he started a company, and he started basically from scratch, no cost, and it's now at some point worth 150 million. And he's willing to actually, at least that first time around, let the government go all the way back, because maybe maybe all the appreciation, all the gain, all the income was 20 years ago, 30 years ago. He's willing in that first cut to say, well, unless you can prove with checks and all the rest, you pumped in a lot of money, oh, that $150 million of current wealth is past congealed income, year after year after year, and I'm thinking, deal, because a lot of the FedSoc folks, won't like that very much, because it's taxing income, but past income of a certain sort, and that begins to look a little like, as a practical matter, a wealth tax, at least for day one. And then after that, he's saying, oh, but then you don't have to keep repaying it again and again and again, although, of course, when you have excise taxes or consumption taxes, you're going to pay every time you buy a yacht, or a Learjet or whatever, there might be a kind of federal sales tax of a certain sort. Okay, so we actually agree on a lot. We agree also on basically why we have the Constitution, and this is not understood, okay? We have the Constitution for taxes. Take a step back. We have a Constitution for national defense, because if you don't have an army, you're dead, okay? And you all are taught that the father of the Constitution is James Madison. Thank you very much. That's completely wrong. Of course, James Madison is 5'4", and no one pays any attention to him, and no one's heard of him. There's a part of your brain that actually knows that, because of course, we're here in Madison, D.C., and we look up and we see the Madison Monument, which is 555 feet tall, and some of you from the West Coast come from the state of Madison. No. Are you absurd? The Constitution is George Washington's. He's the father of the Constitution. He's the father of the country. He's the presiding officer at Philadelphia. He's the unanimously elected first president, unanimously reelected. It's Washington's Constitution, and this is relevant, you see, because it's all about making sure that we can beat the Brits again, because they're going to come after us again, and it's going to be called the War of 1812. That's what it's about. Read your Constitution. Okay, it's common defense, and a perfect union is for common defense, and that phrase appears in the Articles of Confederation, and the problem, and David said that, is you can't have a common defense without money, and they're not paying. The Constitution is all about national defense, and therefore taxes. The slogan of the American Revolution, my friends, is not no taxation, exclamation point. It's no taxation without representation. Now, since you're going to be represented in this new Constitution, oh, they're going to tax you good and hard and up and down and sideways, and they say so. What's the longest section of the Constitution? The longest article? It's Article 1. It's the first and longest, and what's the longest section? Section 8 is the powers. Here's how it begins, the longest section of the first and longest article. Congress shall have power to lay and collect taxes, duties, imposts, and excises. Why? Usually they don't tell you why. They just said do it. But sometimes, if you're really lucky, law tells you why. To pay the debts and provide for the common defense and general welfare of the United States. They're echoing the preamble, okay? But all duties, imposts, and excises shall be uniform throughout the United States. And he said, cloth, you have to pay equally. So we have a Constitution for common defense. Okay? And it's in the preamble, and they repeat it. And we have taxes for that purpose, because without taxes, there's no army, and you're dead. And George Washington understands that. James Madison, not so much. Just in case you missed it, when he's present, the Capitol burns to the ground. Okay? There's a reason he's not there on Mount Rushmore. The idea that he's the father of the Constitution is preposterous, and you have to read the damn book. Okay, because I prove it in here, and I wrote a brief in the Moore case, and it's 10 pages just from the book. So I'm going to tell you, okay, so it's about common defense and therefore taxes, and you don't want to make it hard to have taxes because otherwise you're dead. And David agrees with all of that. Oh, but this apportionment requirement, he told you, it's actually going to make it difficult in various ways, and it's going to be upside down, and rich states are actually going to be taxed at a lower per capita rate than poor states, and that's all weird. And I wish all Federalist Society interlocutors were as reasonable as my friend David, because he's actually agreeing with Alexander Hamilton and George Washington. We should not make taxation actually difficult, because we need it for common defense. Here's your protection, representation. It has to come from Congress, has to originate in the House. You don't like it, vote the bums out. So then why did they have any apportionment requirement? Corinne, that was your question, I'm getting to it. But first, laying the table, we have a Constitution for George Washington, national security, common defense purposes, and you need taxes for that. And this book is dedicated to Lynn Miranda and Ron Chernow and others, because it's all about Alexander Hamilton, and he gets it, and James Madison not so much. And there's a case. It's the most important case that the Supreme Court decides before John Marshall comes around, and almost none of you knows it. I didn't know it 10 years ago. I'd heard of it, but didn't know what it was all about. It's called Hilton. Alexander Hamilton comes out of retirement to defend a tax. George Washington asked him to do it. It's the only time he ever argues a case before the Supreme Court, and he wins it unanimously. And it's all about how we have to have broad tax power. Because James Madison said, oh, this is it's a direct tax, and it's not a portion, and blah, blah, blah. And the Supreme Court says unanimously, wrong. We side with Hamilton and Washington. We have a narrow view of what's a direct tax. And they tell us in this case, this is originalism. It's in the amicus brief. That was submitted to the United States Supreme Court. Here's why we have these special rules for direct taxes. In one word, one Juneteenth word, slavery. Here's the problem. If you can tax cloth at a low rate but uniform, you can tax cloth at a high rate but uniform. You can tax heads of lettuce. You can tax hogsheads of tobacco, okay? Oh, but if you could do that without constraint, you could tax heads of slaves. And you could tax slavery out of existence, and the South won't go for that. So there's special rules when you're taxing heads, because they were worried about taxing the heads of slaves. And today he picked Connecticut and Mississippi, but back then, Mississippi or if its equivalent, how are you going to count slaves? You see, it's all about the 3/5 clause, because it's got to be apportioned by that. So in a nutshell, it was all about slavery. And if you don't believe me, read the Hilton case, because that's what Justice Patterson, who was there at Philadelphia, says. He says it was all about slavery. And if you don't believe me, I'll quote you John Roberts in a recent tax case saying they said it was actually about slavery. So there are only, according to Alexander Hamilton, I'm making an originalist argument, there are only two things that are direct taxes: head taxes for reasons having to do with slavery, and land taxes, and we'll have to talk about what makes land special, and nothing else. Wealth taxes are okay. Taxes on anything else is because we have to, and he said, in a war, if you can't collect stuff at the tariffs, you're going to need to finance that war. You do not want to make it hard to have money coming in during a war, and Hamilton understands that, and Washington understands that, and James Madison doesn't understand that so much, and that's why the Capitol burns to the ground on his watch. And you shouldn't actually pay attention to what Madison may have thought. Washington, Hamilton, and the unanimous Supreme Court have a very, very narrow vision of what counts as a direct tax. Anything except land and head taxes is not governed by apportionment, says Alexander Hamilton in 6 Federalist Papers, says Alexander Hamilton in his oral argument in Hilton, say the justices in the Hilton case, and that's Washington's understanding as well. So it's basically about slavery. Now, here's what I didn't tell you. I didn't give you a full account of why land is different, and we're going to have a conversation, and I think land is different. And is wealth more like land? Wealth today, we can talk about all of that. But my friend David, he doesn't cheat. He's very fair. He's also a very nice guy. He really is. We are friends. And he actually, because this is more of a conversation than a debate, and in a very sweetly reasonable way, I think, actually identified some of the strong arguments for not having a really, really big category of direct tax, because it's upside down. It's going to mean wealthy states actually pay less than their kind of fair share per capita in a way. It's going to make it harder to bring in revenue, especially in a war when the ships can't come into port. And he's willing to say an income tax, at least the first time around, can maybe be retroactive or quasi-retroactive. There are lots of provisions of the tax code that so provide. Well, wow. Then as a practical matter, that's a lot of the ballgame, is the congealed income of many past income periods that's today's wealth.
Dean Schizer, do you agree? Is it all about slavery?
Definitely not all about slavery. So I am incredibly fond of Akhil, but I disagreed with a lot of what he just said.
You can also come to the defense of James Madison if you want to. I'll leave to you.
Poor James Madison could use some defending, that is true. Just quickly, it's true, in agreement with Akhil about this notion of congealed income turning into wealth. And basically, my view is, if I, David, paid nothing for stock 20 years ago, and then I decide to sell it tomorrow, there's no dispute about the fact that that's income today, and the fact that it accrued over past years. It doesn't matter. That's what an income tax does. And if Congress decided to change the rule and say, well, instead of using sale as a trigger, we're just going to institute a different sort of a rule, well, I think it's still an income tax, and we can talk about whether it's the kind of income tax the 16th Amendment authorized. But that's really different from a wealth tax. A wealth tax taxes you every year, taxes you whether it goes up, goes down, and so I don't think I've given away any stores. I think I'm just trying to point out a difference. But now let's turn to this question of direct tax and apportionment. And apportionment is very strange, no question about it. So how do we understand it? Why did they do that? And so it really wasn't only about the institution of slavery, although that was an example of what they had in mind. But I'd like all of us together to do a thought experiment and think about the European Union. And imagine that the European Union got together and said, we'd like to have a taxing power that was at the EU level, and it was mandatory. And I just want you to think about what the dynamics would be in that conversation. Would they be saying, we want to focus on wealthier people as opposed to less wealthy people? I actually really doubt it. I think the French delegates would be thinking about France. I think the German delegates would be thinking about Germany. I think the Hungarian delegates would be thinking about Hungary. And the point would be, how do we protect our part of this union from being overtaxed compared to the rest of the union? Well, guess what? 1787, that was the perspective that the framers brought. Now, I'm cheating a little by going back a few years further than that, but there's a wonderful letter that Thomas Jefferson wrote on July 1st, 1776. He'd been busy writing the Declaration, and he'd been in Philadelphia for a long time. So he writes this letter to a friend in Virginia saying, "It is such a hardship being 300 miles from my country." 300 miles from my country, because Virginia was his country. And we'd had a successful Revolutionary War and a not so successful Articles of Confederation experience. But in 1787, my reading of what was happening is they were jockeying to try to protect their own states. And so what do I mean by that? They were determined to prevent what my co-author Steve Calabresi and I call fiscal raids. And a fiscal raid is basically the idea that the other states will get together and say, hey, there's this practice that exists in this state, but not in our states. So let's impose a national tax on it. And if we do that, hey, we've managed to push the national tax burden off of us and our citizens and onto other citizens. So apportionment is a barrier against fiscal raids. It's a principle of federalism. It's not about the institution of slavery. Now, slavery is relevant because it was a very salient region-specific practice. And so it's true that if Congress said we're going to impose this tax on enslaved people, it would not be paid in Massachusetts. They'd eliminated slavery already. Connecticut had very few enslaved people. They wouldn't pay much tax. South Carolina had 40 times more slaves per capita than Connecticut. And so obviously the burdens would fall on the South. And so in that way, I do agree with Akhil and with Justice Patterson and with other people over the years who'd said that it was about slavery. But where I disagree is it wasn't only about slavery, because there were lots of region-specific phenomena. Even Justice Patterson refers to the fact that the South had a lot of undeveloped land. And this was also part of the reasoning, because if you taxed undeveloped land, you'd hit the South. So even Justice Patterson did not think it was only about slavery. Massachusetts had pretty much all of the shipbuilding capabilities. They were worried about a tax on shipyards. And so you might say, okay, well, how do we know? So here's one way we know. If Akhil is right, then here's what we should see. We should see the North pushing hard for direct taxes, the North resisting apportionment because they were hoping to use direct taxes to target the South and to target the institution of slavery. But in fact, what we see is that the northern states were, if anything, more opposed to direct taxes than the South. So for example, when Rhode Island finally ratifies the Constitution, they do it with an instruction: our delegates must always oppose direct taxes. Massachusetts, similar but different: we will approve this document, but only if you go and try to get an amendment wiping out direct taxes. We don't want them in the Constitution. Connecticut said the same. There are several states in the North that did this. It doesn't make sense. If this was all about the institution of slavery, they were on the wrong side. But of course it wasn't. It was about protecting region-specific practices, and that was a much broader idea, which basically tells you this was about federalism. This was about protecting states from the rest of the country ganging up on them. Now, there's a lot more to say about the scope of direct taxes, but I'm just going to say that I have a portrait of Alexander Hamilton in my office.
He does.
I am also a fan, and therefore I'm so happy that he's on my side of this debate, because it's true, I don't particularly agree with some language in Hilton that other people wrote, but his notes from oral argument say the following, and I'm quoting them, and this is where he was. So it's true, there's some language in Federalist Papers. Akhil is right about that. He's a little casual. He uses the phrase land taxes, taxes on land and heads. I'll explain that in a second. But when was he called upon to be really precise about what he thought direct taxes meant? Well, when he was going to make an oral argument in a case about the question of what direct taxes meant. And here's what he said. It is in a footnote in Akhil's brief, so he knows too. The following are presumed to be the only direct taxes: capitation or poll taxes, taxes on lands and buildings, it's there, general assessments whether on the whole property of individuals or on their whole real or personal estate, all else must of necessity be considered indirect taxes. So there it is, the real or personal estate. He is saying wealth taxes are also direct taxes. I think the justices should have listened to him, but I also think we can reconcile Hilton with my view, and we'll get to that.
Yeah, so I want to dig into that a little bit more about what is a direct tax.
Yep.
So do you agree with Hamilton on his definition of direct tax? Do you have a different view? And then afterwards, Professor Amar, I'd love to hear your view on this as well.
Yeah, so my view is pretty close to what I just read to you. And basically what I would say is the two categories, direct on one hand and what lawyers call indirect, even though the term isn't used, the line is as follows. Is it a tax on a transaction? And so let's start with the language in the Constitution itself. And I just want to be clear about what the debate is. It's a debate between Akhil and me, but it's also a debate that's gone on for a while, and there are a lot of people over the years who've taken the position that Akhil has taken. So, very, very wise people have said this. I just don't agree. They will say direct means just head taxes and real estate taxes. That's kind of their category. Everything else is indirect. I do not agree. So what do I think indirect means? It's a tax on a transaction, an impost. Well, that's so. Okay, sorry. The Constitution itself says capitation or other direct tax. That language, capitation or other direct tax. Well, if they actually meant to say what my dear friend Akhil meant, then they wouldn't have said or other direct taxes. They could have just said capitation or real estate taxes. And just the use of the language or other direct implies something broader. Now, I do think the distinction between direct on one hand and this other category is important. What is the common theme with an impost, an excise, and a duty? It's a tax on a transaction. So again, if you've got a transaction going on, that has to be uniform. And if you're taxing people directly, meaning without a transaction, then that's a direct tax. You've got to apportion that. Now, you can take my word for it, but it's much better to take the word of other people. People like, for example, what's his name again? John Marshall. Heard of that name. So John Marshall was at the Virginia Ratifying Convention, and he was asked what's covered by direct taxes, and he says land, slaves, stock of all kinds, and a few other articles of domestic property. So I, frankly, am not quite sure whether stock refers to livestock or stock in trade, but either supports my view, and of course, articles of domestic property, this is broader. Oliver Ellsworth, another future Chief Justice at the Connecticut Ratifying Convention, talks about direct taxes applying to, quote, the tools of a man's business or the necessary utensils of his family. Luther Martin, an anti-federalist from Maryland, says, by the power to lay and collect taxes, they may proceed to direct taxation on every individual, either by capitation tax, by their heads, or an assessment of their property. Doesn't say their real property, doesn't say land. Now, Hamilton did use the phrase taxes on land. That's true. I think he corrected and was more clear in his oral argument notes, but I just want to share one other thought with you about what taxes on land meant. So if you go back to the 1780s and you look at what the states were doing, the taxes that they were imposing, they also had direct taxes. And these were taxes not just on real estate, but on other things too. Plate, they called it, which was sort of the silver that you had. Some of the states taxed loans. They taxed professions. And so these were omnibus taxes. They taxed a lot of things. And do you know what they were called? Land taxes. They were called land taxes. That was the British phrase that made its way to the colonies. And so I actually think when Hamilton says taxes on land, I'm not sure that he meant real estate. Now, I can't tell you definitively. I'm not sure that that's what he meant at all. So bottom line is, what does this concept of direct tax mean? For me, the text is pretty clear that it can't just be real estate taxes, or they would have said it. We've got framers at the time saying that it was a broader category. And if you're looking for the logic of what they meant by distinguishing these categories, taxes on transactions, indirect, uniformity. Other taxes, well, they had to be direct. They had to be apportioned. So no, I don't think it's just land and head taxes. I think it's wealth taxes are counted.
Professor Amar, how about you? What do you think?
So taxes are complicated, as you just heard. And truthfully, not everyone knows what they're talking about. Who thinks about taxes more than anyone else times 5? And the answer is Alexander Hamilton. Where's the most important place to look? In the Federalist Papers. These are 85 newspaper essays. And Hamilton writes roughly half. How many of them are about taxes? 7. As a little boy, he's playing with toy soldiers and doing sums in his head, because you have to pay for the toy soldiers. This is who he is. And he says emphatically, clearly, in the Federalist Papers, and I think my friend David agrees, it's land and heads and nothing else. He says that actually at Philadelphia. Now that's secret stuff, but at Philadelphia, here's actually what he said. This is his Philadelphia plan. Taxes on lands, this is volume 3 of Ferran's records. Taxes on lands, houses, and other real estate and capitation taxes shall be proportioned in each state. That's his proposal. And guys, here's what I want to tell you. I've been studying this for 20 years. And there are 10 pages in this book, which is way before more about all this. It's dedicated to Ron Chernow and Lin-Manuel Miranda, and Lynn's spouse. Hamilton is your man. If I could resurrect John Marshall right now in a Marshall McLuhan moment, he would just say, listen to Alexander, okay? Because he holds Hamilton in awe, and Hamilton knows stuff.
Can you do that, by the way?
No, unfortunately, I don't have that, Wingardia Leviosa kind of, magic wand power. I wish, that's why he breaks the fourth wall, does Woody Allen, and he says, why can't real life be like this? Okay, because it's not. Hamilton at Philadelphia, I'm going to read it again. This is his account of what should be proportioned. Taxes on lands, houses, and other real estate and capitation taxes. Now, it's true, the words don't say that, but that's Hamilton, and he's thought it through, and he's the tax guy. Then there are 7 Federalist Papers, and he says taxes on land and heads and nothing else. Then he actually argues Hilton. It is true. In some notes, he says something, that seems to go a little bit broader. I talk about this because I've known about it forever. And in footnote 7 of my brief, amicus brief, which I'd like you to read, I take the following position. I'm highly doubtful that these early notes reflect what he actually said at oral argument, and I'll tell you why, okay? Because at oral argument, people play hooky just to see Alexander. Everyone in Congress actually leaves just to see him. All the diplomats come because he's world famous even then. And this is the only oral argument he ever makes. And the Supreme Court justices unanimously back him contra Jefferson, who wasn't even there at Philadelphia, contra Madison, who says, because it's all about a carriage tax. And Hamilton says it's perfectly valid. Oh, but Madison says no. And Jefferson says no, and Washington says, I don't understand any of this stuff. I just signed it because you told me, you came up with the plan. And the Supreme Court justices unanimously, in their opinion, ones who actually reach the issue, say heads and land and nothing else. And they don't know taxes from shit. They don't. Taxes are complicated. Everyone is deferring to Hamilton. And so I don't believe he actually said anything other than land, and because we don't have a tape recording. We just have some early notes that he composed. If you don't believe me, since he's talking about a dead Chief Justice whom we can't resurrect, who said this, by the way, way before he was Chief Justice, let's talk about the current Chief Justice. Okay, here's what he says this is John Roberts in a pretty important tax case called Sebelius. Okay, the Hilton court was unanimous, and those justices who wrote opinions either directly asserted or strongly suggested that only two forms of taxation were direct: capitations and land taxes, and then their page sides. So there are two propositions. You asked me a question, and I was stupid enough to answer it directly. Why did they do it? It turns out, with taxes and everything else, there are a complicated set of reasons. It's a cluster of things. You know, what's easily administrable, what can you measure, what's not upside down, all sorts of things. I don't have to prove to you that it's slavery and only slavery. I don't. I have to prove that it's land and capitation and nothing else. And I've just done that. And he has to prove that this is this fiscal raid thing, and oh my God, there's no strong evidence for this. He doesn't have people saying fiscal raid. I love Steve Calabrese. We co-teach together. You know, Steve comes up with ideas, and then he actually retracts them later on. He, told me, oh, monopolies are unconstitutional. I said, well, that's very interesting, Steve, and I hate them. But the Bank of the United States is a monopoly. And he says, oh, yeah, so never mind. But he published it first. Okay, this fiscal raid stuff. I can actually favor this state or that state, not by taxing one more or less, but by spending more in one state or less. As a practical matter, if I tax oil uniformly, pumping it out of the ground, that's going to actually affect Texas more than it's going to affect Connecticut, okay? He told you about France and Germany today. That's not, we're originalists here. That's why I thought this. Okay, so, in fact, I believe it's about slavery, and Patterson says so, and I can read it to you. Patterson says it's slavery. Now, slavery doesn't fully explain land. That's because there's never just one thing. It's a complicated series of things. So here are my two claims. What the thing actually was understood to mean was land, direct taxes, and head taxes, and nothing else. Evidence. That's what Hamilton says at Philadelphia. That's his Philadelphia plan. That's what Hamilton says in 7 Federalist Papers when people are ratifying. I don't think he says it in oral argument. It's just in some notes. But even if he did, that's many years later. And here's the reason for thinking he didn't say that, because the justices, none of them say that. And they're just basically signing, whatever you say, Alexander, they're just, putting it in their opinion, because they don't know. I mean, taxes are complicated. They genuinely are, believe me. And he knows that, and I know that. Okay, so, done. Now, why did they do it? Okay, I wrote a book 20 years ago. It's called America's Constitution, a Biography. You should read it, because it's actually comprehensive. Originalism isn't about this word or that word. It's understanding the whole system. Here's what I said 20 years ago. Constitution is about 3 things that we haven't been honest. It's way more democratic than we thought. They put it to a vote. Okay, up and down the continent, and if Congress, which is representative, is saying you should be taxed, you don't like it, vote against them. That's democracy. It's way more about national security than you thought, which is why borders are important, and I talked about armies, and I said, oh, it's way more about slavery than you thought. It's not about this fiscal raid stuff. Steve might be interested in that. Ilya Soman might be interested in that. That might be France and Germany today. I'm calling BS on my friends here. I'm saying, you don't have, and Oliver Ellsworth, really? Are you serious? Luther Martin is an anti-federalist. He's opposed to the thing. John Marshall just, blowing smoke, out of his, hindquarters, because he's just vamping. Alexander Hamilton has been dreaming about taxation forever. He's the guy who designs the tax plan and the bank plan, and a currency plan, and he says again and again and again, land and heads, and the heads, in fact, is about slavery. And Patterson says that. Oh, and if we're talking about John Marshall's, how about John Marshall Harlan? Because he says that in Dissent, in the Pollock case. He says it's all about slavery. Lots of people, maybe my friend David, I don't know, maybe my friend Steve, say, oh, even an income tax was unconstitutional. which is why you needed a constitutional amendment. Well, the Supreme Court did say that in the Pollock case, but John Marshall Harlan, the elder, didn't. He says, this is bogus. In fact, we just got rid of slavery. Why are you reading a stupid provision that's going to make taxation difficult broadly after we've gotten rid of slavery? That's all in John Marshall Harlan, as in John freaking Marshall Harlan, as in the great dissenter in Plessy versus Ferguson Harlan. That's in his Pollock dissent, you see. Okay? So, in fact, I think that's what it was about, but I don't need to prove that to you. Okay? But Patterson does say it. And John Marshall Harlan, and so one question, it's a genuine question for my friend David. Was Pollock rightly decided? I think it was preposterous. And you know who signs an income tax into law? His name is Abraham Lincoln, if we're actually talking about names. Okay? So I think you don't need the 16th Amendment at all. The Supreme Court screwed the pooch in the Pollock case, just like they did in the Plessy case, just like they did in the Lochner case. This is an era of justices that actually I don't hold in high regard. The person on the court I hold in high regard is John Marshall Harlan the Elder, and oh, he's on my side. So if you have any doubts, here's what you have to do. Read this amicus brief. It's quite short. It's based on 10 pages of this book, which is quite long, but you have to read the book. If you want more, the Hilton case is very short. 3-page opinions, seriatim. Read them. They're overwhelmingly on my side. And I think David would actually agree with that. They don't say anything about fiscal, raids or anything like that. They just don't. And originalism is taking seriously what Hamilton said on taxes, what Washington agreed to, what the early Supreme Court. But if there were a difference between Hamilton later on and Hamilton when the Constitution is being ratified, I would say ordinary standard originalism would say pay more attention to the Federalist Papers, because that's what, rather than, maybe a mistake he made at oral argument. But I don't think he even made a mistake at oral argument. In fact, again, my evidence is the justices are basically agreeing with him, and they don't say anything more. They don't say wealth. He can't find, he'd love it if he could point to, none of even the quotes he had was wealth or anything like that. He has to say, oh, well, it's kind of like wealth, and it could have said this and that and the other thing. Final point. He says, if it's just land and heads, boy, they could have said that more clearly. And I think, oh, David, you're 100% right. That's true of everything. It always could be more clear. Always, but that's not an argument. You see, I don't have to beat perfection. I just have to have a better argument than my friend. And I think I have to have more evidence than my friend, and I think I do.
And he began by saying you guys agreed on almost everything, right?
Yeah.
So, Dean Schizer, do you agree that the court in Hilton is with Professor Amar and that Alexander Hamilton is with him as well?
So let's take a step back. How often have you heard someone say, would you pass the Kleenex, please? Why is he saying this? Because what I think they really mean is, would you please pass the product, tissue paper, of which Kleenex is the most common example. And I do think that when people said taxes on land, they were actually intending this in the British parliamentary sense, and in the way the states were using it. Taxes on land, those were the omnibus taxes that included more than real estate. And I do think, therefore, that there's substance to the idea that they didn't just say capitations and real estate taxes. It's not what they meant. I don't even really think it's what Hamilton meant when he said it in the Federalist Society, Federalist Society papers. That'd be a good brand for us. In the Federalist Papers, I don't actually agree with Akhil that taxes on land means only real estate. But even if it did, I think Hamilton, the lawyer, was giving a much more precise definition about what was intended, what was the general sense when he was arguing the Hilton case. And I'll just say, I have a picture of Hamilton on my wall. I've told you that already. Doesn't mean that I would support his proposal at the convention, because you probably know it was about a president elected for life. He was going to eliminate the states entirely and have nationally appointed regional governors, his view did not represent the consensus. And so even if Akhil is right about taxes on land, and I don't really think he is, the fact is Hamilton's view didn't control on everything, and it's pretty clear that other people thought this was a broader category. Okay, so I do think taxes on land doesn't necessarily mean what my friend says it means, and I also think it's not in the language of the Constitution. Pollock, I think, as I've told you, that indirect taxes, excises, that's a tax on a transaction. And so I think an income tax is a tax on a transaction much of the time. And so if you're talking about a payment of rent, which was the issue in Pollock, I think that was an excise. I think it should have been upheld. If you're talking about a tax on unrealized appreciation, it's actually not a tax on a transaction. And so my own view, and we can jump ahead to the 16th Amendment at some point soon, my own view is that without the 16th Amendment, that Biden proposal of a mark-to-market tax would not qualify as an excise tax, but a tax on a sale would. I think, actually, my opinion, what they meant in the 16th Amendment was broader than that. We can talk about why. So I am actually with Akhil, but for different reasons, in saying I think a mark-to-market tax would be okay because of the 16th Amendment, but it would have failed under Article 1.
This is very helpful, David, because and your position is way closer to mine and mine closer to yours than I think our friend Steve Calabrese might think. Again, you gave away too much, even on.
We have a different view of the amendment.
Yeah,
that's true.
Yeah. But here's what I didn't tell you, and I think and it's a nice question. Is a bump stock really a machine gun or not? Should we, and the literalists say, no, it's not, and the functionalists say, but it functions like it. So now actually, David has said, Akhil, even if it were just land and heads, maybe we could understand land a little bit more metaphorically, purposively, rather than literalistically. I think that's actually a plot. So now I need to tell you a little bit, and maybe not at this point, but in some go around about why I thought they actually had special rules about land. I told you why they had special rules. I don't need to tell you why, because it turns out tax often isn't just one it's a big stinky compromise, and also on and that on administrability and incidents and all sorts of stuff. But I actually do have a theory about why what was special about land and why wealth today isn't really like land. But or some people could say, our friend Steve might say, oh, wealth today is kind of like land was back then or something. So we should talk about land a little bit more, but I don't want to.
No, please go ahead.
Okay.
And then at some point, I'll get to answer your question about Hilton.
Oh, my apologies. Please.
All right, then let me just say, I don't agree that Hamilton supports Akhil's view. I've said so.
Hilton.
No, Hamilton.
Oh, Hamilton.
I don't think that, so I basically heard Akhil say two things, right? Hamilton's on my side. I don't think so. I do think Hilton is on Akhil's side, mostly. So I do think that. I think that the case can be read consistent with my theory. There's dicta in those cases that is clearly much closer to what Akhil thinks than what I think. Let me start with the dicta, though, because even though, here's what Patterson said. He did suggest, real estate and heads, but he said, it's not before the court. It would be improper to give any decisive opinion on it. Chase says, I am inclined to think, but of this I do not give a judicial opinion. And then he goes on. Iredell, the other opinion in the case, even clearer that we can't give an opinion on that. He says, there's no necessity or propriety in determining what is or is not a direct or indirect tax in all cases. So there was, this is before John Marshall. There was a kind of a looseness to the way the court operated. They're giving advisory opinions. Then they're saying, but, we're not really supposed to do that. So I personally can't put that much stock into the dicta. I definitely don't put any stock into this line where Patterson says it's about slavery, because actually if you look at the rest of that passage, what he's really saying upsets him is that, here, let me see if I can find the quote, but basically what he's saying is, okay, the rule of apportionment is a work of compromise. It is radically wrong, right? So this is something Akhil thinks helps him. It cannot be supported by any solid reasoning, but now listen to his objection. Why should slaves, who are a species of property, be represented more than any other property? The rule, therefore, ought not to be extended by construction. He wasn't talking about the tax part of the compromise. He was offended by the idea that when you were allocating representation among the states, that there would be any representation accorded to enslaved people. And so I just want to remind you, who's heard of the New Jersey Compromise at the convention? Basically, good, the first moment in the convention, Edmund Randolph comes in and says, let's forget about what the Articles did. Every state was equal. Let's represent states by their size or their wealth, right? So that's the big state plan. So who rises up to defend the old way under the Articles, right? Every state should be equal. Well, the representative from New Jersey, that being Patterson. He proposed the New Jersey plan. Did not work. I think there's a lot of sour grapes in the way he's remembering what happened. And so, yes, he was there. But I'm not sure that he's sort of the neutral arbiter of exactly what played out there. In any event, let's go back to the holding in Hilton, because I think that's what's important. And the Akhil reading, and it's a plausible reading, and so again, I think this is the best argument for his view. I want to be clear, I don't agree with the others. I do think this is the best argument for his view, is that it's a tax on owning carriages. And that sounds like a wealth tax when I say it that way. And it's not a tax on all of your property, but it's a tax on a piece of your property. And the court said, nah, it doesn't have to be apportioned. So that does seem like they're saying a tax on wealth other than real estate, don't have to apportion it. But then you look at the reasoning, and then you look at what they actually were doing. Both Patterson and Chase talked about this as a tax on so-called consumable commodities. They were actually analyzing this as a sales tax. You buy a carriage, you're going to pay a tax when you buy the carriage. But here's the thing. The practice at the time, and Patterson alludes to this, and he quotes Adam Smith about it, is that if it was a big-ticket item, you'd pay it over time because it was too expensive to buy, to pay your tax all at once. And so, therefore, what they were really doing, I think, is classifying this as a tax on a transaction. So I actually think you can read the Hilton holding as consistent with our theory. I'm not saying it's the only reading, and I'm not saying it's the best reading, but if a future Supreme Court justice is in the audience and agrees with me otherwise, Hilton is not a barrier, you can simply read it that way. And if you look at the article that Steve and I have written, which has just been posted on SSRN, we show you the language in the case, which explains that really they keep emphasizing it's a tax on a transaction, and therefore apportionment is not necessary.
So my friend David does concede that in form it's not a tax on a transaction. It's a tax on just having a carriage, whether you bought it or not, whether you got it as a gift, whether you inherited it or just happened to have it. So if he wants to focus so much on, well, excises are on transactions, but pay no attention to the fact that technically there is no transaction. But if that's how we're going to do things, then you can say, well, whether it's realized or not, we can treat it as income and blah, 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 because it's a de facto, it's a kind of non-formal transaction. But big step back. I told you why they don't like head taxes, because you could tax slaves out of existence, and the South will never go for that. And this is how the Union fails. It's all about slavery. It's a very big thing, and the tax people don't know this, okay, because they only look at one little thing. This is why I'm writing books about the entire Constitution. I have thought about every provision of the Constitution, and slavery is there in a whole bunch of provisions. You need to understand how it fits together, and Patterson understands that because he was there, okay? So, if you really want to decide whether I'm right, you're going to have to read not just this book, but a big, fat 500-page book called America's Constitution, a Biography. And you're going to see actually how the thing fit together. And judges try to, they try to look at Constitution in little microscopic slices or something. And I'm telling you, it's about democracy, slavery, and war.
And federalism,
Yes.
which is my theory.
Yes.
Yes,
But,
yes.
but federalism, hold on. But not this fiscal restraint thought, because sometimes you're going to need to pump money into this region or that region. And so it matters, and I'll connect to land, whether it's Madison or Washington. Madison says a carriage tax is unconstitutional. He does.
Mm-hmm.
And Jefferson is joined at the hip with him on all this. And it's a luxury tax, and they don't like it because they see it as taxing rich people. And not to put too fine a point on it, this is a technical legal term, but they get their asses kicked at the Supreme Court. Unanimously, it smacks them down and says, we're going to follow George Washington, who signed his name to this bill, and Alexander Hamilton, who drafted it and is now defending it. Okay? So don't pit James Madison and Thomas Jefferson, they don't understand banks at all. They literally believe that every bank is a Ponzi scheme. That they do. That if you don't keep all of your reserves in the vault, and if you lend money out against that, that's actually just a scam. That's actually what Thomas Jefferson, it's in the book. Okay? He doesn't understand how banks work, or trade, or army. So it's Washington's Constitution, and Hamilton is his right hand, but they've got to get the South on board, and the South will never accept something that could allow heads of slaves to be taxed, and therefore slavery to be taxed out of existence. Now I need to explain what land is all about and why there are special rules about land. So first, I want to build on what my friend David actually is seeing out of the corner of his eye. The Articles of Confederation system didn't work. What did the Articles say? They said actually states are supposed to pay up a requisition, based on, basically the wealth of the state. But wealth turns out to be a really hard thing to measure. So they basically say, well, we're going to use population as a proxy for wealth. Okay, but then how to think about slaves? Because basically, if people can move around, they'll move to where from poorer states to richer states, and so roughly people are easier to measure. See, this is a tax. The principle might be wealth, but that's going to be hard to measure. So people are going to be easier to measure. Oh, and they'll move basically from poorer places to richer places, so it'll kind of even out in the end, roughly, crudely. How do we think about slaves? And the South says, oh, they're, the slaves, they shouldn't be counted at all. We have to feed them. You can't get any work out of them. They should be zero. And the North says, oh, you should count them a ton because you can whip them and work them really hard. They should be counted at one or more than one. And that's where the 3/5 clause originates. It's in the Articles of Confederation, a debate about a proxy for wealth. And then it gets used in the Constitution mainly for representation. And some people, like Patterson, are annoyed about all that. But in order to hide all of that, because the Northern delegates are embarrassed that they're giving away so much to the South on representation. To hide that, in part, they connect it to direct taxation, and some people in the North don't even realize that, and they actually, because for this purpose, the North, if they're smart, should want it to be zero. You shouldn't count slaves at all for representation. Whereas before they wanted to count very highly for taxes. But the taxes aren't going to come from direct taxes. We've just acknowledged that almost all the taxes are going to come from ports and other things where the direct. So this is all, actually, this is the worst part of the Constitution where the delegates are actually trying to hide from their constituents what it's all about. So there's camouflage going on, such that some people in the North, these clueless people in Rhode Island and Massachusetts say, oh, it should be 5/5 because we want actually the South to pay more, not realizing there are going to be very few direct taxes in America. It's going to come from the customs house. Okay. But they had another thing in the Articles of Confederation. They said, actually, there was a proposal for figuring out how much each state should pay with a land assessment, because you can actually assess land. It doesn't move around. It's not fugitive. So in their heads, this is originalism of a certain point. They're connecting head taxes with census, because that's how you count heads, with land, because that's actually how all this was cashed out under the Articles of Confederation. And now here's one final point. So they're thinking about land. Two final points. Second, the zero problem. And David knows what I'm talking about, and maybe some of you. Here's the problem with calling something a direct tax, because it has to be apportioned. Okay? So suppose actually you tax carriages. If it were a direct tax, let's say there are two states that, just to keep the math easy and just no slaves. So equal population, two free states. Equal population, if they have the same number of carriages, then you can have the same carriage tax, and it'll generate, total revenue apportioned to each state. Suppose, though, there are two states, same population, but one has 100 carriages and one has 10. Well, you have to get the same net revenue if it's direct tax from each. So now you're going to have to tax the state with 10 carriages at 10 times the carriage rate to get the same. And that's maybe the poorer state, because carriages are a luxury item like yachts. That's upside down and makes no sense. And they say all of this in Hilton, but now one state, just to screw the other, says we prohibit carriages in our state. Okay? So now that state has 0 carriages. Dudettes, you can't divide by 0. So now you can't have a tax on carriages anywhere, and that screws everything up. And in theory, there could be 0 hogsheads of tobacco, so that can't be treated as direct. 0 carriages, so that can't be treated as direct. You will not, though, ever have a state that has 0 persons, nor will you have a state that has 0 land. So you don't have the problem, the 0 problem, with land. Or you could actually have a state with 0 net wealth because people have borrowed against it and all the rest, okay? But you can't have a state with 0 land, and you can't have a state with 0 people. And land can be assessed in a census. You can't assess very easily every day the value of wealth. It fluctuates every day. And the final point is they're living in a world where people are land rich but cash poor. They have a lot of land that they've inherited, but they can't turn it into ready money. And there's perceived distinct unfairness. This is like California Proposition 13. If, I have a house, and maybe on paper it's worth a lot today, but some people say, but it's not fair because I don't have any money to pay for the unrealized appreciation. Now, I'm not that sympathetic because you can borrow against it today because we have thick markets, you can use your equity as a piggy bank and all the rest. But back then, so I don't think we should read land broadly. I think we should read it narrowly because back then, taxes on land created hardships for people who had inherited a family estate and now have to sell it in order to pay the tax man. And we don't have that problem today for most assets because we have such thick markets and easier even assessments such that we can mark to market and all the rest. So David made a really interesting argument. Even if it were just about land, let's see wealth today as the modern equivalent of land. I say, no, let's not do that, because the reason that land taxes were treated specially and we want to make land taxes hard don't exist today, actually even for land, because you can borrow against it, but especially for all sorts of other assets that are very, very liquid. So in 3 sentences, and then I'll end here. So I say, unlike fleeting, consumable, and easily alienable assets like carriages, whiskey, tobacco, etc., land was fixed and permanent. It was possible to imagine a state with 0 carriages, but not one with 0 land. Like population, land values could be made part of a manageable decennial census. unlike many other items that would be much harder to count in every census, whiskey barrels, tobacco hogsheads, and the like. And this is why I said because it's June 19th, slavery. In fact, it's a complicated cluster of things, and David will tell you, because he teaches tax, and he's a brilliant tax teacher, that's probably true of like every tax issue. It's a whole complicated, cluster of considerations, truth be told. When you actually, why did they draw the line here and not there?
So I want to switch gears a little bit so we have time to get to questions for everyone as well. Unless you have been completely checked out for the last hour, you may know that there's a case before the Supreme Court right now, U.S. v. Moore, that takes up the issue of whether the 16th Amendment allows taxing unrealized gains. And again, unless you've been totally checked out, you probably picked up on the fact that Professor Amar has filed an amicus brief in that case,
and so did
which
I.
you should read, and that Dean Schizer has as well, which you should also read.
And even Steve Calabrese has one, which you should also read. So there are 3 different positions. His is far, far more reasonable than my friend Steve's, by the way.
But assuming everybody doesn't have that on their beach reading list for the summer, could
Why
you guys,
not? You're actually going to the beach instead?
Could I ask each of you to kind of summarize your positions in those amicus briefs, and then if you can, give us a guess on how you think the Supreme Court's going to turn out in that
I'll
case.
just say one thing, because I want to hear David first, but I think the majority will probably go with David's approach. And so it'll probably be decided on your approach, which is very sensible, and maybe there'll be a concurrence on Hilton and all the rest. But why don't you tell them your approach first? Because I think actually yours is going to be what convinces the court.
Good, but first I want to thank you for, in your last couple of sentences, agreeing with me that it isn't only about slavery.
It isn't. No,
Okay,
I
good.
overstated it, just in part because it's Juneteenth and get people's attention. It's in taxes or anything else, it's probably never just one thing.
We could go on for hours about this, and I would enjoy it. But I know that I have to shift gears to more. So I'm just going to spend a minute explaining the issue to those of you who don't know it. Then I'll tell you my position, and Akhil will share his. So back in 2017, Congress was thinking about the following problem. When you had a multinational corporation, U.S. company with foreign subsidiaries, the law then was that if the foreign subsidiaries were earning money, the U.S. wouldn't tax that money, generally, until the foreign subsidiary paid a dividend up to its parent. And the effect of that was paradoxical and not desirable, and I think few would defend it. It meant that U.S. companies really wanted to keep their cash out of the United States. $2.5 trillion sitting in foreign subs of U.S. parents. And if you think about what a country tries to do, discouraging investment in the home country is pretty much the opposite. So people knew this had to change. So Congress said, we're not going to make the dividend the key anymore. We're going to start taxing this income at a reduced rate. It actually has the wonderful acronym of GILTI, global, low tax intangible income. So basically they said, okay, doesn't matter, we're going to tax it before it's brought home, but what do you do about the $2.5 trillion? In theory, they could have said, well, when dividends come back, we'll look and we'll see where the cash came from, and if it was earned after 2017, we won't tax it, and it was earned before, we will. And that's a nightmare, right? Because money is fungible. So what Congress did is they passed the mandatory, the repatriation tax. They basically said, for everything that's out there, one-time tax. Reduced rate, we'll tax it, and then everything else that comes back, there's no tax consequence. So then you have the petitioners in this case, the Moores. They had bought stock in an Indian company. It's not a multinational, they're US individuals owning the stock. And they said, wait, what's going on here? You just taxed us, and we never sold our stock. And so they said, that's not authorized by the 16th Amendment, because we think the 16th Amendment, when it says taxes on income, it means realized income. So the court grants cert, basically on a cert petition that says, we'd like you to decide the question of whether the realization rule is constitutionally required. My position in the amicus brief is that issue is not presented here. And basically what I said was, because there have been realizations here, the realizations were down in the company level. And so the question is not, can you tax without a realization, but can you attribute a realization at a company to the owners of the company? And I think the answer to that is yes, because for those of you who know how partnerships are taxed, that's exactly the system. What happens, Akhil and I and Corinne, we form a partnership, 1/3, 1/3, 1/3. The partnership sells something. We didn't sell it, but each of us is going to pay tax on 1/3 of the income. And the Supreme Court said 100 years ago that was fine. So basically, what I believe is that the Supreme Court has an off-ramp here. There's a challenging question about whether the realization rule is constitutionally required. I have a view, I can share it, but I just don't think it's presented here. And so I was interested, the first question on December 5th in the oral argument was Justice Thomas, who said, can you tell us about the difference between attribution and realization? And for the next 2 hours, pretty much the entire discussion was a debate about the theory that I'm describing. So my prediction is that's the way the majority will go. They'll uphold this, not deciding whether realization is constitutionally required, but just by saying, actually, this is not really a test for that proposition, and so we affirm the statute. I predict also there will be a couple of concurring opinions. It looked like Justices Alito and Gorsuch were very concerned about taxing unrealized gains, and I predict that they will have a concurring opinion saying that's a difficult question, but it awaits our analysis, but we're concerned. And by the way, a wealth tax, definitely a no-go. One of my favorite moments in the argument, by the way, was when someone asked the representative of the Solicitor General, well, what if it was a wealth tax and you're just taxing every year? And she said, oh, that's definitely unconstitutional. So she agrees with me. But in any event, I also think we're probably going to get a concurrence. Justice Jackson seemed to be alluding, Akhil, to your theory, possibly saying, I don't care about the 16th Amendment. This would all be fine anyway. So let me turn it over to you to talk about your theory.
So that was great, but please actually tell us what your theory is about the constitutional issue of unrealized income, but genuine income, but not realized in the transaction.
Yeah. So I think, so for me, the question is, what was the public meaning of the term income when the amendment was ratified between 1909 and 1913? And so I will give you my view, and I'll give you a potential counter-argument to the view. My view is the Supreme Court had already affirmed the idea of depreciation. And what depreciation is you can take a deduction before you actually sell something. And so the notion that we were measuring things just based on a sale had already been rejected by the court. And income really is an idea that comes from the accounting field. And in accounting, back in the early 20th century, they were already doing things that didn't depend only on when the cash was flowing. So I think income to the framers of the amendment was more like what an economist would say, and frankly more like what a 21st century tax lawyer would say, which is, oh, if you're taxing something that went up and there's no sale, that would still be income. So I think the meaning then was that. But if you were looking to make a counter argument, the question is popular meaning to whom? Because I just gave you the meaning that I believe experts would have applied. But I also think that if you consulted voters in 1913, and by the way also in 2024, and you said, you've got stock, it appreciated, do you have income? I think there's a fair number of people who would say, no, I don't think so, because I didn't sell it. So I'm not saying this is a slam dunk, but for me, I would apply kind of the technical meaning within the profession, and I think it's income under the amendment.
And our friend Steve Calabresi thinks there has to be a realization.
He does,
correct?
yeah.
And we disagree with him.
We do.
Yes.
Yeah, we do.
So, and we're all friends. Yeah, I've co-authored stuff with him, and you co-authored stuff
We were
with him,
friends
and
before tonight. We're going to have to check.
So I think I agree with just about everything you said. I might go in prediction. I might go even a little further and say, I wouldn't be surprised if the Chief Justice wrote the opinion for the court. And he doesn't need to decide certain things, and you didn't feel that you needed to take positions in your amicus brief. And I'd like them to say all this. I agree with you that income is an economistic word, and Irving Fisher was the preeminent economist of his period. He was a Yale economist. We're double Yaleys both, and the Irving Fisher definition of income is basically just the delta of wealth. Income is just the difference between your net wealth at time t1 and time t2. It could be positive, it could be negative, it could be zero, but that's what income is. Your wealth is the amount of water in the bathtub, and the income in any interval is, the net would be, the gross would be how much is coming into the spigot, but then there's outflow through the drain, and the net is, just has the level of the water risen, then you have income, or fallen, then you have negative income. It's just, that's what it is. And it's not about realization, selling, buying, dying, whatever. It's just, is your wealth going up or down? Now, David, as I said, he's such a sweetly reasonable person at the very beginning, because when you basically said, well, your current wealth, at least for the first time, the first transaction, we can, in effect, go all the way back and presume that your original baseline was zero, and that was all at some point income. Yeah, it might be income, but way before we passed the current law, or even the income tax amendment or something like that. So if you're willing to let us go all the way back, that's a lot. It matters still going forward whether you tax everyone $2 million every year because they're still wealthy or something like that.
Can I say a word about that?
Yeah.
Well,
if Corinne permits.
I permit.
Okay, good. So look, it's not easy biologically to still be alive and to have accrued income before 1913. So putting that fact pattern aside, I just want to observe it's utterly conventional, and no one has ever questioned the idea that if I bought stock 20 years ago and I sell it tomorrow, I got gain, even though it accrued over the period. And by the way, they might have changed the tax rate.
Exactly.
Right? Like they changed the tax rate this year.
And a tax lawyer would understand that, but Steve, who doesn't teach, he has a problem with that.
I don't find the congealed wealth idea persuasive, but what I do want to emphasize, it's 2 points that may sound different, but I'll say them anyway. First, I find the impulse among progressives to push for a wealth tax strange, because most of what they presumably want to do, they could do through an income tax. Right. I have a friend who is a Democrat, I'm clearly not, as you can tell, who jokes about how when he was on the Hill, his boss would come in and say, "What do you have that's fresh and new?" And he'd say, "Not a lot, but I have some good ideas for the tax law." So I think maybe this flirtation with wealth taxes, it's just because it's different. I don't know. Having said that, I also think that wealth taxes are worse than income taxes. Again, for the thing you're glossing over, which is, tax me when I made money, fine. Tax me once, fine. Every year, even when it's going down, really? Like, that is a different thing. And again,
but you and I both believe that even if you've already paid your income tax, you can be taxed for all the consumption and your luxury consumption. A carriage is a luxury tax. It's a tax on yachts. So, and that's fine by me. One final point, and then maybe we can, is, on my view, you didn't need the 16th Amendment at all.
Right.
So I don't care so much whether it's income or not income, realized or not, attributed or not, because I'm with Mr. Lincoln, who signed an income tax into law and thought that the original Constitution permitted that. And the Supreme Court, in a case called Springer, said that was all fine, and then changed their minds 5-4. And John Marshall Harlan is in dissent, and he was right in dissent, and he said it would be a disaster for the country, and the people rose up and smacked down the Supreme Court. They've only done that 3 other times in all of American history. Dred Scott, and the 11th Amendment in Chisholm versus Georgia, Dred Scott, and saying, blacks are citizens, and with the 18-year-old vote in Oregon versus Mitchell. So the people rose up and said, Pollock was wrong. We're with John Marshall Harlan. I think it matters if they think they're just changing the rules going forward on retroactivity and other things, or if they actually think we're, in effect, this is declaratory that this always should have been the understanding. The court hates admitting that previous justices have made a mistake on anything. They still haven't, overruled the slaughterhouse cases. They have nonsense talk in a whole bunch of domains. We call it substantive due process rather than privileges or immunities, because they don't want to admit that some of these past cases are problematic. But just the issue. If you didn't even need the 16th Amendment from a strict point of view, that might have some technical implications.
And just a reminder, I do think we needed it in this case. I think the 16th Amendment changes the rule because when you have a transaction, and I should be precise, when you have a transaction, you can tax it as an excise. Without a transaction, I don't think you can, but I do think that the 16th Amendment allows you to tax income that way. Mm-hmm. My view of Moore, there were transactions at the subsidiary level, so we're fine.
But here's the tricky thing, as you admitted before, there really wasn't a transaction in Hilton. Technically, it's on the ownership of a carriage and not on the sale or transfer of the carriage.
No, it isn't actually what both Patterson and Chase said when they were explaining.
Right, it's just when you look at the law, which is not a bad thing to do. It's actually look at what the law actually says. Yep. The law is not about sale or transfer or anything like that.
And since Akhil likes to transport back in time, I'll do the same thing and say that if you wanted to do a sales tax and try to tally up how much someone owed and to let them pay it over time,
it would have been a disaster.
You would need tax collectors.
Yes.
And they didn't have them.
Correct.
Which is why I think it's pretty clear this is what they were doing, and they just couldn't write it that way.
Right.
So I do think that Hilton can be squared with my view, but I also think it's closer to
But on that
Oregon.
very view, if you say, well, you should have a transaction, but today when we actually have assessments and markets and all the rest, I can tell you what my portfolio is worth at this nanosecond, whether I've sold it or not. So why don't we, again, now it's administrable and it wasn't before, so why not treat every day that I choose not to sell as an implicit blah blah blah, which is, and lots of implicit stuff in tax law.
Yep. Can I answer? Yes.
So
we have to get some questions.
If folks want to start lining up at the mics if you have questions, just so we'll know if there are people who do, but otherwise.
And David, maybe offline, I'll tell you the story actually at some point involving me and Boris Bitker about actually who came up with the theory in Pollock and how we're personally implicated by all of this. Because it was a Yale man who came up with this theory. And since we're double Yaleys, it's a fun story. But you want to tell them the answer to?
Oh, yes. Look, I think the constitutional category is defined by whether there was a transaction in Article 1. Again, just going back to the meaning of duties, imposts, and excises. There were transactional taxes, direct taxes were the other thing. I don't think that's the way the 16th Amendment works, which is why when you say, well, today it's different, I say, yeah, under the 16th Amendment for income, you can do it differently, but I don't think Article 1 gives you that.
All right, let's start over here, and if you could say your name and where you're from before you ask your question, please.
Cool, yeah, I'm Connor Fraley. I'm a 3L at the University of North Carolina. My question is really for both of you on this taxation clauses being about slavery. Article 1, Section 9, Clause 1, that's a very specific limitation on the tax that you can place on the importation of persons, and it's also tied in. So what is the relevance of that very specific provision about taxation of slaves in terms of your respective arguments to that?
Brilliant. So they're trying to close every door, the slaveholders, okay? So if you can tax slave heads that are existing at any rate at all, That's going to mean that a possibly future Northern-dominated legislature is going to be able to tax slavery out of existence. So we prevent that from saying, oh, it has to generate the same net proportional revenue, 3/5 adjusted, state by state. But now there's a different way that we're worried about what Congress is trying to do. Before 1808, we're worried that they might just close the spigot on new slaves. These are imported slaves. So we say you can prohibit any other article of interstate commerce immediately, but not slaves. There's a 20-year window. Oh, but suppose they don't prohibit slaves in that 20-year window. They try to tax them like they tax other things, and so then they actually have a cap on the tax on imported slaves. So I like the question because you're seeing there are a lot of provisions in the Constitution, and they all interlock, and slavery ramifies. We have the Electoral College because of slavery. You were taught, oh, it's balanced between big state and small state. No, the big state guy wins every time. We've only had 4 small state presidents in all of American history: Franklin, Pierce, Zachary Taylor, Joe Biden, and Bill Clinton. And who's the winner of 8 of the first 9 elections? Of Virginia. That's the biggest state. Okay? So it's not a big state, small state balance. That's the House and Senate. Oh, we have it because it's a democracy, not a republic, Professor. No, no one reads the Federalist 10. It's not about Madison. They put the Constitution to a vote. That's not why we have it. The electors are never making independent judgments. They're not a college. Yale's a college. Princeton's a college. No, these guys are potted plants from day one. The Electoral College is all about slavery because without an Electoral College, the North would win every time because the South can't count its slaves. They don't vote. But with an Electoral College, Virginia gets to count its slaves, albeit at a 3/5 discount, and 8 of the 9 elections are won by a slaveholding Virginian. Yes, you have to see the whole thing, and judges don't because cases are litigated clause by clause by clause, and you have to see the whole thing. Oh, you're going to have to read a scholar who's going to write about the Constitution as a whole. Who might that be? Okay, so yes. No, it's not just about taxes. It's about a lot of things. And yeah, it isn't just about slavery, but this is just a correct understanding that there are lots of provisions. That's another one. That's about a slightly different issue, which is international importation, the international slave trade from the Caribbean and from Africa. Just so. Yes.
So I'm just going to add, there's another provision which says that you can't tax exports. And what's that doing there? Again, I think the point is some regions exported, some regions didn't. There was a great deal of anxiety about how our region was going to be treated within the Union. And so, although Akhil wasn't persuaded by my Germany-France analogy, I think all of you should be. Not because I'm talking about that as originalism, it hasn't happened yet, but because it's a way to understand what really was happening at the convention, which was federalism, states protecting their turf.
I'm so glad he mentioned that because that's all about one region exporting one thing, which is the South exporting tobacco, which is the product of, or later cotton, slave labor. So they don't want to use the word. They're embarrassed. And Lincoln says that. So they say, a person rendering service, other person. They're embarrassed. But the export thing, he's trying to generalize it into, some sort of fair thing among the regions. And I'm saying, no, it's all about export, because another way of taxing slavery out of existence is preventing tobacco from being exported.
And who had the ships that were bringing the tobacco?
Oh,
Massachusetts.
Lots of people that are implicated, which is why there are cotton wigs and conscience wigs and all the rest, which is another reason, actually, why your fair share idea can't be cashed out. It would be a horrible constitutional doctrine. It is not constitutional doctrine today that every expenditure or tax or regulation really has to have some a quotified, a disparate effect, actually equality across the different regions.
It is definitely not. And Governor Morris, when he proposed apportionment and tying the 3/5 of representation to taxation, which you mentioned before, but you kind of left this out, he originally wanted to do it for all taxes. And then people said, but it doesn't work except for direct taxes. And he said, okay, direct taxes.
And that's because, again,
it's a limited doctrine.
And
but
he's
it is
a lawyer,
there.
most people don't understand how taxes work, and he definitely didn't. And he's the lawyer in the group, and he's a beautiful writer, and he writes the last draft. But had his version prevailed, that would have been utterly idiotic.
And he
couldn't work.
conceded it. He
Yeah.
conceded it. But again, for direct taxes, this is what they wanted to do. They didn't do it for every little thing, so you're attributing
But he
something
was,
I didn't say. But
and in a whole bunch of other ways, he's actually helping the Northerners camouflage the deal because he knows this is going to actually be unpopular when they go back to their home states and try to get the Constitution ratified and try to get elected to the first Congress. If they actually say, yeah, we caved to the South on all this because we had to. So, and he says, in fact, this was, he almost uses the word camouflage or fig leaf or something when you read, all of Farran. This was a way of trying to hide fact, some of the Northern cave in because they don't, and they hide it by not using the word slave, by saying persons owing service or labor, other persons, exports. There are a lot of stinky deals having to do with slavery, and the Northern delegates know what it's about, but they truthfully, they don't want their constituents to hammer them for it, their Northern constituents.
Hi, I'm Matthew Stanko, president of the University of Maryland undergraduate chapter of the Federalist Society. I had a quick question regarding income and the difference between a real increase in property values versus a mere nominal increase in property values and how that factors into your analysis of what is income.
So the Constitution tends to focus on nominal rather than real. The reason, when you read the Constitution holistically, so does $20 mean $20 in the Seventh Amendment? Yes. Here's why I say so. Because judges' salaries can't be decreased, but they can be increased. Presidents' salaries can't be increased or decreased, either one. Why? Because presidents actually only have 4-year terms, judges have lifetime terms, and they expected there would be inflation. Okay? So you're going to have to increase judges' salaries. Tell your mom I said this. Her mom's a judge. Because they're going to be around for a long time, a president can suck it up for 4 years, and then there can be adjustment for the next term, presumably behind the veil of ignorance going forward. They expected inflation. Now, they actually tried at first to say, well, can you actually peg this to some, and they actually were talking about, but they don't have the bureaucratic capacity. Can you have a COLA-like thing, a market basket of goods, and then which is the proper measure of inflation? Because Paul Krugman will tell you there are 8 different measures, including groceries or not, including gas or not, including rent or not, including, but they actually, I don't know, David, if you ever paid attention to this, Madison initially proposed it, could we peg it to the price of wheat? Did you know this?
I did not.
Oh, yes,
I did
he
not.
actually proposes a kind of crude way, and it just turns out they said, no, that's just not going to work so well because wheat isn't the only price in the world. So when you read the Constitution holistically, it's utterly clear that they're focusing on nominal value and not real. Now, in a sensible income tax, you could take the position that if you're only keeping up with inflation, you're really not any better off.
And the truth is, lots and lots of people have proposed over time to do more indexation in the tax code.
Yes.
And one clumsy effort at that is one of the justifications for having a lower capital gains rate than an ordinary income rate is capital gains usually applies to something you've held for a while, and there's an implicit recognition there that all of your gain isn't really gain. Some of it is inflation. But I would be interested in real indexation. It's a conversation for another day.
But some things are in the statute books indexed, like Social Security and other things, and others aren't.
And tax brackets.
Do you know what really pisses off the judges? Is there was a time that they made kind of more than we useless law professors, and now not so much. So this is like farmers used to talk about parity, which were farm prices between 1909 and 1914, and try to peg it to that or something. So for judges, parity was back in the 60s when they had life tenure and we had life tenure, but they got paid more than us, okay? But they didn't peg it. Like our salaries are going to be pegged to law professor salaries or to the price of wheat or to the consumer price index or whatever.
I think judges' salaries are pegged to members of Congress. And if I'm right about that, and I think I am, then I think that was a strategy on part of Congress to think we could have an excuse to raise our pay. And the problem is there's been a certain reluctance on the part of Congress to raise their own pay, which in my opinion means judges are tremendously underpaid.
I agree that judges are tremendously underpaid.
So glad that we're ending on agreement.
Tell your mom that, okay? So.
We are unfortunately out of time. The good news is we're going to have a reception afterwards, so please bring your questions there. If you haven't already gotten a copy of the books by our two panelists, Dean Schizer's book is How to Save the World in 6 Not So Easy Steps, and Professor Amar's book is The Words That Made Us. Again, a nice light beach read for the summer. So please join me in thanking our panelists for being here with us tonight.